We thank you so much for watching Voices of the Bar, where the legal world speaks. We ask you to subscribe if you have not yet subscribed, and we ask you to share and keep liking our videos. So we want to discuss foundations of law, how to answer, what they expect you to answer on every topic. What are those things they want you to answer on every topic? And we shall begin with foundations of law, and we shall start with hierarchy of courts. So when you discuss hierarchy of courts, they expect you, number one, to introduce the judiciary. That in Uganda we have a whole judiciary under Article 126, and then you introduce the courts of judicature under Article 129. Then from there you now introduce the Supreme Court under Article 130. You now talk about 131, which talks about the Chief Justice and others. Then its roles, duty. Look at Article 133. Talks about the duties. The Chief Justice may direct, give orders to enhance the efficient administration of justice. Then you look at Article 104 of the Constitution. That requires you basically to talk about the Supreme Court as a court of first instance when handling presidential election petitions. Then from there you talk about Article 132(4) that talks about the precedents, that the Supreme Court that its precedent will be binding on all the other lower courts. Then also you bring the idea that it can depart from its precedents, former precedents that was set by itself actually. Okay. Then from there you go to the Judicature Act. You bring the composition under Section 3 of the Judicature Act that discusses now the composition of the Supreme Court, and then you must also assert the point, I think, in the Criminal Procedure Code Act, which talks about the Supreme Court as a second apparent court or third apparent court, depending on where the case comes from. That way, you would have answered well the issue of Supreme Court. Then we go to the Court of Appeal, and we are saying under the Court of Appeal, we are going to look at Article 134, which creates the Court of Appeal. Of course, its mandate, and then, of course, the leader being the Deputy Chief Justice. But before, in the Supreme Court, talk about the Chief Justice being the head of courts in Uganda. Then the Deputy Chief Justice, who sits on the Court of Appeal as the head. Then you bring Section 9 of the Judicature Act, which talks about the composition. And then you give a case which was on appeal and it was handled in the Court of Appeal. And also you explain the fact that the Court of Appeal deals with appeals from the High Court, and that's very important. Then we go to Article 137. That says that the Court of Appeal will sit as a constitutional court to answer all matters regarding constitutional interpretation, human rights violation, and others. So you give an instance where constitutional matters were held in the constitutional court, but also stress that this is just sitting as a constitutional appeal, meaning that the people who are in it, the deputy justice and others, are the same people who handle the constitutional court. So these ones sit together, and then you bring Section 9, which talks about the composition, and there you are basically done with the Court of Appeal. Then we cross to the High Court. We look at Section 138 of the Constitution, which creates the High Court, gives it its mandate, headed by the principal judge. Currently, we have Judge Abodo as the principal judge. Then you talk about its pecuniary jurisdiction, that it handles matters of 50 million and above. Then you talk about Article 139, which talks about the unlimited jurisdiction of the High Court in all civil and criminal matters. Then we also talk about having one High Court, and then talk about the High Court circuits, which have been created to ease the work of the High Court in different areas, because not everybody can come to Kampala at the High Court, but those other circuits which have been created to help on the work of the High Court in different areas: High Court of Mukono, High Court of Mubende, High Court of Hoima, High Court of Chibo, no? High Court of Fort Portal, Kawale, and others. Then we now cross to the Magistrate Court, the Chief Magistrate. Very important to note this from, I think, Article 129, that talks about subordinate courts, that the High Court, or before the High Court, we talk about the precedents under the High Court, that the High Court will handle all appeals. It also handles appeals from Magistrate Grade 1 and the Chief Magistrate. That all appeals from Magistrate Grade 1 and Chief Magistrate under the section of the Magistrate Court Act, it should be section 1. Okay, it has skipped my mind, but there's a section there that said that the Supreme Court, the High Court shall handle all appeals from Magistrate Grade 1 and the Chief Magistrate Court. Then you talk about, then you also stress the idea that the Supreme Court and the Court of Appeal and the High Court are the only three courts of record. We have courts which set precedents. They are the courts of record that set precedents. It's very important to note when trying to discuss in your essay. Then from there, we go to the Chief Magistrate. We talk about his jurisdiction, civil and criminal jurisdiction, the matters it's supposed to handle, matters in civil and then criminal, and then we talk about the pecuniary jurisdiction, that it handles 50 million and below. Then the Magistrate Grade 1 handles 20 million and below, so meaning that the Chief Magistrate handles 20 million to 50. Then the Grade 1 handles 20 million and below. Then that's the pecuniary jurisdiction. You talk about the civil. You can also, if you want, talk about the, of course, there are civil and criminal jurisdiction. Then Grade 2 Magistrate is being phased out. Then we can now have what we call the LC courts. You also talk about the LC courts. That way, you have really talked. So for Magistrate, you need to read those 160 sections under the Magistrate Court Act. Magistrate Court Act, the sections are 160 and above, 207, 160, around there. They used to be around there, but I stand that you check and find out the right section. Then let's cross to sources of law. When you are asked about sources of law, first thing, they must be in order. They must be in order. In order, we mean, in order, I mean that they must be in order: Constitution, Acts of Parliament, Common Law and Equity, and then you talk about case law, and then common, and then customary law. But members, note, after discussing those 5 primary sources, then you also bring the secondary sources. Don't forget, you write about the secondary sources. But under here, under Constitution, they want you to first talk about Article 2 of the Constitution, that is the supreme law of the land. Okay? Then Article 2 of the Constitution, that any law or custom that is inconsistent with this provision of the Constitution, that law shall be declared void. Then from there, you talk about a case, Andrew and another, where they found that the seditious intention and seditious offense were inconsistent with Article 29 of the Constitution, and they were scrapped off. Yes. Basically, you go in that line. Then you come and talk about the Acts of Parliament. You begin by Article 77, which creates Parliament, then Article 79(1), which gives Parliament the mandate to make laws. Then you talk about Article 79(2), which gives Parliament the mandate to delegate others to make laws. And then you talk about the principle of delegatus non post delegare, that a delegate cannot delegate further. If Parliament delegates to you, then you cannot delegate further. You give examples of cases here and very many others. That way you have discussed the Act of Parliament, then you give an example of some of the Acts of Parliament, you give them. Then from there we talk about the common law. Common law, you state the common law principle that these were man-made judgments, law in England, which we received on 11th August 1902. Talk about the reception clause, and then you give a case where we applied the common law. There's a case of Jita. There is also another beautiful case of Uganda Motors versus Whoever Holdings, where we use the common law principle that where the fire starts from, that is the place which the fire started, the direction of the fire, which was applied in that case, meaning that we had come. Then you use the Statute of General Application, the Judicature Act, which was introduced here. You talk about it. Yeah, and then you can now cross to equity, that equity came to remedy the common law, where common law was insufficient. Equity would come and remedy. Then you talk about those equitable remedies or maxims of equity, that who comes to equity must come with clean hands, that equity aids the vigilant, not the indolent, equity is the quality. You talk about delay defeats equity, and very many others. You can even talk about Article 132E. Yes, 132E. 2E, with that undue technicalities, that equity will look at the substance rather than the form. We don't look at technicalities. We give that case of Stephen Barbosa. So you run in that way. Then you go to case law. You talk about ceteris decisis, that principle in the common, that principle that let the decision stay. You talk about precedents. You give cases where precedents. You talk about the importance of precedents, cases, you know why, and then you are done. Then talk about customary law. You talk about our customs, the characteristics of customary law. You know, it must not be inconsistent with the Constitution. It must be known to the people. Those things. Then you give cases. Mifumi case is there for you. Best Kemgisha versus Meboko Muntari is there for you. You can even bring Harlem, KO, and others. So that way you are done. Then you go to the other side, or where we have the secondary sources, and then you discuss the secondary sources. Then from there we are going to look at let's look at which other topic? Let's look at ADR, Alternative Dispute Resolution. Our colleagues under ADR take cognizant of the question about ADR. They may ask you, discuss the advantages, disadvantages of each. They put the word of each. You just give the general, get me that each. So when discussing ADR, you define what ADR is, talk about arbitration, you talk about mediation, conciliation, all those ADR mechanisms, but discuss each advantage, disadvantage, advantage, disadvantage, advantage, disadvantage. Discuss each advantage, disadvantage, advantage, disadvantage, and then you are good to go, each one of them. Or you can give a general advantage and disadvantage, but discuss each one of them. That is a number. Even if they ask you for advantage and disadvantages, you begin by discussing alternative dispute resolution. You give the types, and then you go to the advantage and disadvantages. And then from there we have a number of how to teach law. Now under here, how to teach law, they can use the word discuss the pedagogies. And then people say, they say the pedagogies, me, I don't know. but all there they mean to discuss law, to discuss they mean that discuss the law, discuss the methods. So when you talk about them, you say Socrates, you give the meaning of Socrates, and then you give advantage and disadvantage. You say discussion method, you define the discussion method, you give the advantage and disadvantage. Lecture method, advantage, disadvantage. Online method, advantage, disadvantage. Like that, like that, like that. So there you're good to go. Then you talk about school of thought, philosophers. Here you must know each philosopher, okay? And then you must know which school was he under, okay? The theory that for example, if you're talking about the natural school, you should know about Aquinas. What was he promoting? Why did he bring it? Why is it? You answer in that. Anyway, there are videos about the school of thought, so in here you have to look at them. Then you have the classification of law: civil law versus criminal, civil law versus common law, substantial versus procedural. So here you don't need to say this civil is this, while law this is this. Just say civil law and criminal law. Then you talk about civil law, then don't talk about criminal law. You give examples, then you go substantial, then you go procedural, like that, like that. You keep explaining each one of them like that. Then the other number is precedence. That is if they were taught. Here you define what a precedent is. You talk about the ceteris decisis, and then you give what we are calling, you give the types, which are original, binding, persuasive, declaratory. You explain what each one of them mean. Original is been there for the first time. Binding, it is binding on Uganda and all courts. Then we have persuasive, just persuasive, common law cases. Then we have declaratory, the principle was declared for the first time, but the law was there. Then you give advantages and disadvantages of precedents, and then you are done. I think those are some of the topics we think you have covered this semester, and we wish you well in your papers. Thank you for watching Voices of the Bar, where the legal world speaks. Until next time, cheers. Thank you.